Cynthia Montgomery. Good morning, Counselor. Also represented by Mrs. Rubrick. Good morning. You're all in charge of total, not piece of money.
Correct. But actually, I don't charge by the client. I charge by the 10th of the hour, as you know, they do.
I'm sure you're enjoying your 20 hours here today.
Senator, you do our profession no good, right?
Bad jokes.
We don't need more lawyers.
Good morning, Ms. Montgomery. Thank you for being here. Do you have a statement you'd like to make?
I do. Senator Page, Representative Kruger, and members of the Government Oversight Committee. I'm Cynthia Montgomery, Chief Counsel for Governor LePage. Aaron and I did.
Excuse me, Ms. Montgomery. Pardon me. I forgot to swear you. Can you raise your right hand? You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Aaron and I didn't collaborate on our opening statements, so I didn't prepare to introduce myself to you, so you'll have to be talking to a complete stranger. In the interest of using our time most efficiently, I do want to begin by letting you know that my direct first-hand knowledge of the events that are the subject of your investigation is very limited. My first real involvement in these events did not begin until June 23rd, when Attorney David Webert gave me a call on behalf of the Speaker. That's not to say that I was completely unaware of the Governor's objections to Speaker Eves being hired by will-hinckley, but I wasn't directly involved in those events. In sum, there are 3 events that are mentioned in the OPEGA report that I have first-hand knowledge of and can certainly speak to you about. The first is my communication with Attorney Webert. Secondly, I was present at the cabinet meeting that Deputy Commissioner Desjardins mentioned. And third, I did reach out to Jack Moore at the end of July, or probably earlier than that, but tried to schedule an interview for the end of July in anticipation of the litigation that Attorney Webert had suggested he would be filing. I never did conduct that interview with Mr. Moore because the veto questions arose. And of course, we prepared for that toward the end of July, early part of August. And in that interim, outside counsel was obtained for the governor, so I never did conduct that interview. With respect to these 3 events, I am certainly more than willing to answer any questions you may have. I also would like to address some of the speculation regarding my willingness to answer your questions. As you know, up until today, I have declined all invitations to answer questions about the governor's and the speaker's dispute. I do want to make it clear that I haven't refused to be here out of fear or a desire to hide anything, or as a result of any disrespect for this committee or the work that you have to do. I do recognize and understand that you have a job to do. I hope that you'll see that I do as well. When OPEGA released its report, I did find it to be both thorough and comprehensive in terms of what I actually knew. I believe then and believe now that the relevant facts have been found and fully identified. I'm here today because it did become clear last month with your vote to issue subpoenas that some of you thought I might have additional factual information that's critical to your inquiry. Based on my reading of the OPEGA report, I don't think that's the case, but to the extent I am able to contribute to the fact-finding, I'm prepared to do that. And with that, I'm ready to answer your questions.
Thank you very much. Chairman Kruger?
Thank you, Mr. Chair, and thank you, Ms. Montgomery, for being here today. We appreciate it. When and how did you first learn that Speaker Eves had been hired or was in the process of being hired for the position as president of will-hinckley?
It's a difficult question for me to answer, and I'll tell you why. I remember kind of in a, you know how you can kind of know things are going on in the background? So I certainly knew about the governor's letter in the newspaper. I heard or overheard people talking about will-hinckley. As I said, I was present at the cabinet meeting, so I heard a comment there. In terms of actually knowing specifically that will-hinckley had hired the speaker, you know, and that the governor may or may not have said something about funding, that kind of thing, I really learned about that from Attorney Weber, the details.
And that was in, later on in June?
It was third week of June. I think the report says June 23rd, and that seems about right.
Did you have any knowledge prior to this time that the speaker had applied for or was being considered for the position?
No, I mean, not until I heard that he had been hired. I didn't know anything about that prior to that.
Did you have a specific reaction when you did hear the news?
Personally?
Yeah.
No.
To your knowledge, when and how did the governor first learn about Speaker Eaves hiring for this job, or if he was in the process of being hired?
I have no direct knowledge. I mean, I've heard Mr. Chadbourne's testimony today. I've read the OPEGA report, but I personally directly did not. I don't know.
Could you tell us what you know of what the governor's reaction was when he did hear the news? Any particular action or people that he contacted?
The only thing I can tell you about, I assume, is the cabinet meeting. I know he made an offhand comment at the cabinet meeting about Speaker Eaves being hired. So, you know,
But-
that's the best I can.
But you didn't hear or witness any reaction from the governor?
Upon him first learning, no.
Did anything else occur between the 5th of June and the 8th of June that was in regard to these matters and the governor or the education staff?
Nothing I had direct knowledge of.
And he didn't ask you to get involved in any way at that point?
To the extent you're asking about any communication between me and the governor specifically, communications between me and the governor would be protected by attorney-client privilege. And that privilege belongs to the client, not the attorney. So to the extent you want to delve into those conversations, I'm afraid that I just can't answer your questions.
Can I ask, are you saying that there were conversations, Ms. Montgomery, you're just not prepared to talk about them because of a claim of attorney-client privilege?
Senator Gates, if I may, I believe what the witness is telling you is that she is the standing counsel to the governor. She has routine conversations with the governor that are attorney-client privilege conversations. If you're asking, has she had any privileged conversations of any kind with the governor, the answer to that question is clearly yes. If you're asking her to confirm whether her privileged conversations with the governor include particular topics, that too is a privileged matter.
Well, let's talk about that for a minute, because I respectfully disagree. The attorney-client privilege when it comes to public attorneys is extremely limited. So if I might ask this question, Ms. Montgomery, did you have discussions with the governor with respect to the will-hinckley hiring decision, other than the ones you've told us about? I don't, with all due respect, even that is not protected by the attorney-client privilege, even for private attorneys, whether the subject was discussed. Are you prepared to answer that question?
Mm-hmm. One thing I would like to do is, I do want to stand by my testimony that initially, when all this was kicking off, June 5th and 8th, and I think that was initially the question between June 5th and 8th, I really was not involved and don't have direct knowledge of anything that happened up until really June 23rd.
Okay, so I apologize for interrupting you,
That's all right.
Mr. Chairman, but so your testimony here is that you did not have any discussions with the governor about the subject of the will-hinckley hiring decision, at least until June 23rd. Is that your testimony?
My testimony is, I don't have any direct knowledge about any of those events before June 23rd.
So the answer to my question is no, you did not have any discussions with the governor before June 23rd on the subject of the Goodwill-Hinckley hiring decision?
To the extent that you're asking me to confirm a subject matter that I may have had a discussion with my client about, I'm refusing to answer.
Perhaps at this point we might hear from. Well, let me ask Attorney Rupert this question, because the rule, as you know better than I, with respect to government lawyers, is very limited. Let me read you that rule and ask you to tell us how this plays out here this morning. But the Rule 502, which talks about attorney-client privilege, says the lawyer-client privilege does not apply to communications between a public officer and his lawyers. And only if there's a finding that disclosure of that conversation would seriously impair the public officer's ability to process a claim or carry out a pending investigation, litigation, or proceeding in the public interest. The lawyer-client privilege will only apply to those communications. So how is the answering the question about whether she talked to the governor about the Goodwill-Hinckley matter covered by that rule?
Senator Cates, respectfully, there are two issues. One is the question of an evidentiary privilege and the privilege rules in the rules of evidence. And the other is the ethical duties that you and I, Ms. Montgomery, and all licensed lawyers owe to our clients to maintain confidences and secrets, which is broader than the attorney-client privilege, and that is a duty that is binding on us. I think that Ms. Montgomery has tried to tell you the nature of her involvement in these affairs, which is very limited. But now I think you're pressing her to answer a question that neither you nor I nor any licensed lawyer would be comfortable answering, which is a question from a person saying, I know that you are this person's lawyer, and I know that you have privileged conversations with them about conversations to give them legal advice. And now I'm asking you, do your conversations include this particular topic? And that strikes me as not fair game, and one that any lawyer would be very comfortable answering just voluntarily without checking with their client. That doesn't strike me as it should be particularly puzzling to any lawyer. As far as the evidentiary rule and the scope of the attorney-client privilege for public officials, as you know, the matter that is...
I'm sorry, go ahead, sir.
The matter that is under consideration here, as you know, and as Ms. Montgomery has told you, her involvement started with a call about private litigation between Speaker Eves, apparently in his personal capacity as a private citizen, against the governor individually, and he sought out counsel. And I mean, we know he sought out counsel on that matter, and that is how her involvement started. So we get into an area that's very uncomfortable, and that really, I'm not sure it bears on the committee's investigation. Ms. Montgomery has had no involvement in the matters that are really laid out in the subpoena, that is, discussions about funding, policy-making discussions about funding, discussions with Goodwill-Hinckley about the hiring, discussions with Goodwill-Hinckley or Means or anybody about the selection of Speaker Eves, and she's told you that already. And it feels like we're simply pressing a lawyer as far as we can to the point that would make any lawyer really uncomfortable, and I'm not clear to what purpose.
Well, are you suggesting, sir, that her testifying that she never discussed something with the governor would somehow violate attorney-client privilege?
I think that when you have someone who is your standing counsel, who anybody can expect you to routinely consult with on legal matters, I think the question do your consultations with your client include this topic? That's really no different than asking a lawyer, did your discussions with your client cover this aspect or that aspect of a legal issue?
Yes, Mr. Chair, I've got some questions that I think we're a little bit stalled on, and I suspect maybe other members of the committee do too, and I'm going to request that the committee go into executive session with counsel to discuss this. Is that agreeable?
Discuss this with Deputy Attorney Pfister.
Yes, with Chief Deputy Attorney General Linda Pfister and our staff.
Discussion with respect to the motion.
Yeah.
Formally, I don't know if you want to refer to the motion that references.
Right,
the
right. I'm
statute.
sorry, yes, I should. I have that. I'm sorry, I thought I had the motion right here, but I don't. I move that the committee go into executive session to discuss information obtained in executive session made confidential by Title III, Section 427. Did I get that wrong?
For lack of a second.
Restating my motion, I move that the committee enter executive session to take testimony of witness? No, I'm sorry. Oh, I'm sorry. My apologies to everyone. I'm stumbling here. I wasn't ready to make this. In accordance with Title I, Section 405-6E, I move that the Government Oversight Committee go into executive session to consult with our attorney concerning our legal rights and duties in connection with the situation we're in right now with a witness refusal to answer on attorney-client privilege.
Discussion with respect to the motion. Seeing none, all in favor?
Mr.
No,
Chairman.
oh, I'm sorry, pardon me, Senator Diamond.
Thank you, Mr. Chairman. I'm uncomfortable going into executive session on this issue. I just want to say that. And I guess could we be a little more specific as to what we're going to be dealing with Ms. Cynthia on this question? I'm sure a lot of folks would like to have us go into executive session for a lot of reasons, and so I really am very uncomfortable with that. So could we be a little more specific?
I think the purpose of the executive session would be to get advice from our attorney about whether or not we should press forward with inquiring about conversations Ms. Montgomery may have had with the governor on the subject.
That would be the only question.
That would be it. Senator Johnson.
Thank you, Mr. Chair. And clarify so that the question of whether to press forward be a matter of our understanding what our legal rights and powers are versus those that have been communicated, where the line is drawn on what we may proceed with in the law.
That's right. Further discussion? And we'll, if we, all in favor? Opposed? Motion carries. We're going to briefly be in executive session. And rather than asking all of you to leave, I think what we're going to do is try to go into this little conference room off the hearing room to talk with our counsel. We won't be very long.
How was that?
We need to get something done. They have to leave it. You know that I have a long experience. Keep going.
First day with a new mouse.
1/10 of the hour.
So this was easier, huh? Okay.
Hi, I'm good. Guess who's turning 20 What has happened? It doesn't seem like it's possible. No. You used to park her buggy right outside your office. Oh, how are you?
I guess I'll use the opportunity.
Yeah. I remember when she was girl. Does she have all
We apologize to everybody for having gone into executive session. I just want to make sure everybody understands why. This question about attorney-client privilege, we needed to hear from our own counsel of legal advice about what the parameters of that rule are, and it's appropriate for us to come in executive session. That's the only thing we talked about, and I can't tell you what the discussion was, and no one here will, because that's the whole deal with executive session. But we're now, there's nothing nefarious. So we're ready to go ahead. And just so that I've spoken with Counsel Ruprecht about this, about where we're coming down on this issue, and there may be specific objections to questions going forward, but the attorney-client privilege when it relates to public officials is extremely narrow. It's governed by a specific rule of evidence. And just to read the beginning of it again, the lawyer-client privilege does not apply to communications between a public officer or agency and its lawyers. However, if the court, or in this case the committee, yes, determines that disclosure will seriously impair the public officer's or agency's ability to process a claim or carry out a pending investigation, litigation, or proceeding in the public interest, the lawyer-client privilege will apply to communications concerning the pending investigation, claim, or action. A lot of fancy language, but at least it's clear to me as a chair it doesn't apply here. So what we're going to ask is that Ms. Montgomery answer questions about her conversations with the governor on the subject of this matter, except to the extent that if the governor is asking her for advice, that statement by the governor asking for advice, or anything Ms. Montgomery may have told him in terms of giving advice, would be privileged, but nothing else would. So I hope that's relatively clear moving ahead. And this is a pretty new area for Maine law to even be dealing with. So thank you for your indulgence and let us talk it through. So why don't we go ahead, and Ms. Montgomery, let me ask you this question. At any time, did you have discussions with the governor about the decision by will-hinckley to hire the speaker, or what implications might be for funding of the school by that decision?
While you were in executive session, I did have the opportunity to consult with my client, and I'm authorized...
Your attorney. Oh, your client, excuse me.
My client, yes.
Thank you.
And my attorney, as a matter of fact. But I'm authorized to answer your question. No, I did not have those discussions.
At any time?
Correct.
Before or after June 23rd, which I think was the date we were using in the early questions.
June 23rd was the date that I really got involved in the whole situation. So if you're, maybe I need a little clarification, because I do want to be clear that I'm authorized to answer the question that no, we did not have those discussions. I think the original question was about between June 5th and June 8th, but I might be wrong.
Well, let me ask you this. What was the date you were contacted by Attorney Webert, who's the speaker's attorney?
I believe it was June 23rd.
Okay. So before you were contacted by the attorney for the speaker and became aware that litigation was a possibility. We had no conversations with the governor on the subject matter of the will-hinckley funding issue or the speaker's hiring. Is that your testimony?
That's correct.
Thank you very much. Good.
We may have already gone through this, but could you remind me, were you present at the cabinet meeting on June 9th?
Yes, I was.
Do you have any memory of the governor reacting to the news at that cabinet meeting of Mark Eves' hiring?
I remember the governor making one comment, perhaps. It was an offhand, can you believe they hired somebody who's not qualified, or I can't believe they hired Mark Eves, or it was something like that. It was one comment. I've given you two, but that was the nature of the comment, and I wouldn't characterize it as even venting. I mean, that was a comment.
So as you recall it, there wasn't a discussion by the cabinet or at the cabinet meeting of this particular item.
That's correct.
There were other things obviously. On the very last sentence on page 14 of the OPEGA brief, it mentions Mr. Moore telling OPEGA that Mr. Chadbourne contacted him at some point to inform Mr. Moore that a lawyer would like to speak with him. You provided emails to the committee, which we appreciate, that show that you contacted Mr. Moore on July 20th, expecting that Mr. Chadbourne had already mentioned this to him.
Yes.
It also shows that you arranged a meeting with Mr. Moore through Goodwill Hinckley attorneys for Thursday, July 23rd. Though you ended up needing to reschedule that meeting. The emails do not indicate anything about when that meeting was rescheduled for. Can you tell us your purpose in contacting and wanting to meet with Mr. Moore, and did you meet with him, and what was discussed?
The purpose, really the reason I reached out to him was by that time it was clear that litigation was in fact going to be filed. I can't remember when the lawsuit was actually filed, but it was around, that's what I wanted to talk to Mr. Moore about, was in anticipation of litigation, because I'd received a phone call from Attorney Weber prior to that. We never did end up actually rescheduling the meeting, and I did not interview him, as I mentioned, because the veto issues arose, and that was a pretty intense 3-week period there when I was otherwise occupied.
Okay. Other than the interactions and communications that have already been discussed here, please describe any additional interactions or communications that you've had with anyone at Goodwill Hinckley Means or with their attorneys at any time regarding the hiring of the speaker.
There are none.
Does that include funding issues?
That's correct.
So the decision or the threat or whatever of withdrawing funds, you were not consulted on that matter?
I think you asked me if I had any conversations with anyone at Goodwill Hinckley, and I did not.
Could you describe any interactions and communications that you were involved in with the governor or others in the governor's office on this subject matter that we might not have mentioned so far?
I believe the answer to your question is there aren't any, so I would like to hear your question again just to make sure.
Well, it's actually, I'm trying to get to what else we can flesh out in terms of the communications in the governor's office about the decision to withhold funding. That's where I want to go.
Okay.
And if you're his attorney, I would have assumed that the governor would have talked to his attorney about the decision to withhold funds. And I just want to know if you've had any conversation on that regard.
I did not have any conversations with the governor about the funding or withholding funding. I had no conversations.
Does that apply to Goodwill Hinckley as well?
Yeah, yes, you mean people employed by Goodwill
Yeah.
Hinckley? That's correct. I
Okay.
didn't have
So
any
you were not-
conversations with anyone who's with Goodwill Hinckley except Mr. Moore, and it was just that time period trying to schedule the interview, and then we didn't have it.
Did you discuss or have any interactions or communications with Commissioner Desjardins about this subject material in this time frame, May, June, July?
I believe after the decision had been made about the funding, I think that's when I heard, with holding the check, I believe that's when I heard about it, and I did hear about it from the Deputy Commissioner.
Could you describe any communications or interactions you might have had with Greg Powell or other representatives of the Harold Alfond Foundation about funding?
None.
You've had none?
None.
Are you aware of any other interactions and communications between the governor or other governor staff with Mr. Powell or other representatives of the foundation that have not been covered in the OPEGA brief?
No.
Have you had any interactions or communications with the speaker or his staff regarding this? And if so, when did they occur and what was discussed?
No.
The OPEGA brief does describe some exchanges between you and the speaker's attorney on June 22nd and 23rd that you mentioned. Are you aware of any other interactions or communications between the governor or other people in the governor's office and the speaker or the speaker's attorney that have not been captured in the OPEGA report?
No.
At any time since OPEGA began this review on July 1st, have you been involved in coordinating or discussing with the commissioner or others at DOE what documents would be provided to OPEGA?
By discussing with them, I guess I want to be clear. I didn't direct any production of documents or that kind of thing. I did ask that a copy of the documents provided to OPEGA be also given to me.
At any time since OPEGA began the review on July 1st, have you been involved in coordinating or discussing with Mr. Moore or others at Goodwill Hinckley what documents should be provided to OPEGA?
No.
Are you aware of any conversations or communications regarding documentation?
With people from Goodwill Hinckley?
Yes, with Goodwill Hinckley.
No.
And would that also be true with the Harold Alfond Foundation?
That's correct.
So you were not. Okay, that's mine. Thank you.
Thank you. Any other questions? Representative DeShane.
This is just a quickie. When the senior policy advisor informed the board president that you wanted to speak with the board, that was really just to get your own arms around the situation. It was not under discussions with anybody else.
That's
You
right.
were just prepping yourself. Thank you.
Yes.
Further questions? Senator Johnson.
Thank you, Mr. Chair. Ms. Montgomery, did you described earlier having no direct knowledge of the matters prior to the 23rd. Can you tell us who provided in the course of the cabinet meeting on the 9th or other occasions before the 23rd, any indirect knowledge? Who, if we want answers, should we be consulting?
I'm not sure.
You were asked about your knowledge of the funding discussions, about responses, reactions to Speaker Eves' hiring, and basically stated that you had no direct knowledge. Can you tell us what indirect knowledge, who is the source of the indirect knowledge that came your way regarding these topics?
I'm not sure I totally understand your question, but certainly Mr. Chadbourne had information and Deputy Commissioner Desjardins had information. I assume that's what you're asking?
And that's all
There
you can
certainly
recall for any knowledge that you obtained indirectly regarding the Goodwill Hinckley hiring and regarding funding?
I can't think of anyone else. You know, certainly people were talking about it. I read some of the newspaper reports, you know, that kind of thing. There's definitely no one who hasn't been identified by OPEGA or interviewed by them.
So, if I might
Yes.
ask a quick question. The cabinet meeting on the 9th, you said there was no discussion of Eve's hiring other than the offhand comment that you
That's my recollection,
indicated
yes.
happened. Was there anything else relevant to the Means School that was a topic of discussion in that meeting?
Nothing that I remember.
Thank you.
Senator Dunn, I'm sorry.
No, that's okay.
Then Representative Mastracchio.
Thank you, Mr. Chair. Just need to fill in some blanks
Sure.
here. Thank you for being here. When were you hired to be the governor's legal counsel?
Well, I've done 2 stints. Last year, for 3 months, I filled in while Carly McLean, the governor's chief counsel, was out on leave.
Can you just, excuse me, those 3 months were when? When was that?
I believe they were February, March, April, May.
All 14?
Sorry,
Okay,
14, yes.
14, yes.
And then this year, I was hired at the beginning of February, along with Mr. Chagworth.
And that's his full-time legal counsel?
Yes.
Does he have any other legal counsel other than you?
There's a deputy legal counsel, Hank Fenton, but other than that, we're at. I should correct a little bit. I did, at the beginning of February, I actually agreed to fill in until the governor's office might find legal counsel. And then eventually the governor asked me to stay. And so that's when I really became full-time permanent.
And how would you describe your job responsibility with the governor?
How would I describe it? The scope of it is enormous. It's very challenging, and
Basically covering any and all topics regarding legal issues?
any and all topics. It's the scope is huge.
Thank you.
Representative Mastracchio.
Thank you, Mr. Chair. Ms. Montgomery, thanks for being here. I just have, and I apologize if you already answered this, but I just can't recall it in going through the notes that I have. On June 22nd, on June 23rd, that's when the Speaker's attorney told OPEGA that the governor's chief counsel contacted him by telephone and informed him that she had conferred with the governor and he would not withdraw his threat. Now, that's in the report. Is that a good characterization of what happened from your perspective?
Attorney Weber and I had 2 phone calls. He called me first to let me know he thought he had a claim for constitutional retaliation, that he had some case law for me to look at, and wanted to know if the governor would change his position with respect to the Speaker. I told him I would get back with him. So maybe on the 23rd is when I got back with him. Maybe we talked on the 22nd, I got back on the 23rd, or talked on the 23rd and I got back on the 24th, whatever. I got back with him, and I didn't say the governor won't withdraw his threat. I said the governor's not inclined to change his mind about the Speaker. I do recall saying that specifically.
So you specifically spoke to the governor then about the issue and asked him about it, or were you just giving that opinion based on yourself without talking to him at all?
I do want to be careful. The reason I'm pausing is, again, I want to protect communications between the governor and I that are potentially privileged. But I agreed when I spoke to Mr. Weber the first time to talk to the governor, and then I would call Mr. Weber back after having done that, and that's what I did.
Mr. Chair, I'm not quite sure how to ask this question, but I would like to know that conversation.
I think that in fairness to the witness, the rules we discussed were that in conversations which she may have had with the governor after it became a real possibility that there might be litigation would be protected by the attorney-client privilege.
So I'm not asking what advice you gave him, I'm just asking, so she did discuss with the governor the threat of the funding being withheld. Is that a legal question? Is that okay?
Well, I think discussions that she had with the
I'm sorry.
Right,
I'm not a lawyer, I apologize.
My law professors would be appalled that I'm in a position where to be asked to rule on anything. But I think that the distinction is that once the speaker's attorney called her and said there may be litigation, that any conversations after that are off limits.
May I have one other question? And it isn't about that, so I will abide by his ruling and not ask another one. But you did say something about speaking with Acting Commissioner Desjardins.
Yes.
About the funding issue? Or did you ever have a discussion with Commissioner Desjardins about whether the funding was was in jeopardy for will-hinckley, or anything around that area of issue?
I
funding?
didn't have a conversation like the one you described, but after Commissioner Desjardins had made the decision about holding the check, it was sometime after that he told me about having done that. More than likely, I really learned about that for the first time in the press and then heard from him, but I don't have a specific memory about that time. So he did talk to me about that, though. Tell me about
But you don't remember what the conversation, what it was about? Why would he bring it up to you? I mean, I'm just.
I do remember.
Would you have a problem telling us if I
No,
could?
I don't have a problem. He told me that he was in a staff meeting of some sort, and there was a point in the staff meeting where there was a question about whether to hold a check that was going to will-hinckley. I remember him saying, I paused for quite a while, and he told me his thought process was, it's easier to hold it than it would be to get it back, and that he then decided it should be held.
And the date of that, do you have general?
That's the problem.
In relation to the cabinet meeting, in relation to?
I
mean,
don't
just
even
curious.
know
I don't
what
even know.
day the staff meeting was, but I'm sure that's in the OPEGA report, and it was definitely after that had occurred.
Thank you, Representative. Other questions for Attorney Montgomery? Senator Johnson.
Thank you, Mr. Chair. Ms. Montgomery, I believe in your opening statements you said something about having no knowledge prior to June 23rd regarding these matters we've been discussing. And moments ago, you said that you spoke with Attorney Weber on the 21st.
No, I didn't. I certainly didn't mean to say that. If I did, I misspoke.
Perhaps you could clarify for us.
There's a date in the OPEGA report, I believe it's June 23rd, that OPEGA has found that we spoke. And I think that there actually are emails that would say for sure whether it was June 23rd or June 22nd. Attorney Weber and I had 2 conversations, and I believe they were on 2 different days, back to back.
And what I think you said moments ago was that he contacted you on the 21st with an inquiry regarding whether the governor would consider rescinding his position on the...
I think either it was the 22nd and 23rd, or 23rd and 24th, is what I believe. I don't believe it was June 21st.
With anyone, what documents would be provided to OPEGA as part of the review? And I think you said none, but wasn't there an email from the Commissioner of Education asking you for some guidance on what should be provided and not provided?
There was an email, him asking me, and I didn't really advise. I let him know that in my opinion, as you know, I raised some question about OPEGA's jurisdiction with respect to examining the governor's exercise of executive authority. I let the commissioner know that I didn't think those same arguments applied to agencies, and therefore he, would need to respond to OPEGA, and I wasn't advising one way or the other. To be fair, I know that I did say to him and probably Susan Bodwin, and I want to say Deb Plowman, if you're asked to testify, tell the truth. I remember saying that specifically.
Thank you. And as I would with every witness, I'm just going to inquire into documents. You've produced all the documents that you are aware of that in response to the subpoena request?
Yes.
And they're copies, so we don't need to give them back. Is that
Correct.
Okay. Thank you very much. Thank you for being here.
Thank you.
Thank you, Counsel, for being here. The next person we have asked to testify would be Tom Stark. I'm not sure what your title is these days, so I would say.